Welcome back to O'Connor Tonight, and boy has it been a week at the Supreme Court. We've been seeing case after case after case go down. Seemingly yesterday, the end of affirmative action, although between you and me, I'm not quite sure that those colleges are quite willing to give up racial profiling in their acceptance policies just yet. But we actually got some relatively good news today that religious liberty wins. The case of 303 Creative out of Colorado has seemingly been a victory for religious liberty. The person who put up this case won their trial, and I'd love to have somebody on to talk about it. Now, who could we get? Perhaps Sarah Parshall Perry, a senior legal fellow over at the Heritage Foundation. She probably knows what she's talking about. Sarah, welcome to the show.
Thanks for having me, Doug.
Of course. So for those of us maybe who weren't as well informed about what this case was, could you maybe give us like a brief primer on what exactly the justices decided today in the case of 303 Creative?
Yeah, this is a tremendous win for the First Amendment. Lori Smith is a website designer, but she's a Christian, and she doesn't want to have to communicate messages with which she doesn't agree. Well, Colorado's Anti-Discrimination Act, which you may remember from the Masterpiece Cake Shop series of cases against Jack Phillips, was challenged on First Amendment grounds on what's called a pre-enforcement challenge. She hasn't actually been charged with a violation of COTA, but she is bringing a pre-enforcement challenge because she wanted to make sure that she would not be forced to create wedding websites for same-sex couples. Now, she serves everyone equally, but she just doesn't want to have to communicate messages with which she does not agree. So the court today, in a 6-3 opinion, issued in an opinion by Justice Gorsuch, joined by the conservative bloc with the 3 liberals in dissent, as I think many of us suspected, said today that this was a form of expressive speech, that the creation of websites is precisely the kind of artistic content that the Supreme Court in the past has held to be protected by the First Amendment. And even though this is subject to anti-discrimination law, when anti-discrimination law abuts principles of free speech, the free speech principles under the First Amendment as a primary principle in our nation are to prevail.
Absolutely. Well, again, this seems like a very positive development, but I'm very curious as to how this maybe impacts the average American. So is this sort of a warning from the Supreme Court that if states try to infringe on religious liberty rights or First Amendment rights relating to disagreements between certain parties, are we saying now that like the average American is basically to point to this decision and be like, no, you can't compel me to speech based on this case?
Yes, and actually there are a series of cases that the court cited specifically on those periods of sort of American history where anti-discrimination law in public accommodations have abutted principles of free speech. But Neil Gorsuch was very careful to say that those anti-discrimination laws, public accommodation laws, are not immune to principles of the First Amendment. Yes, we have an interest in protecting everyone in the United States, but simply expressing a message that someone disagrees with is a compulsion that our Constitution and our First Amendment will not allow. This was a good outcome for the First Amendment, for freedom of speech. And in a pluralistic society like ours, these are principles that should not be controversial.
It does seem a little odd that there was this massive push to sort of controvert American principles in this Supreme Court term. We mentioned and we showed a little bit of B-roll around the affirmative action decision. And we have the President of the United States saying things like, this is not a good court, or we have people saying that like this was an affront to justice, when it's really just kind of reverting to the mean, right? You can't judge people based on their skin color, whether or not they're going to succeed or fail. What does it say about this term that like these were sort of these base level issues that we needed to relitigate?
Well, I think they say 2 very good things about this court. As far as statutory law is concerned, these justices are largely textualist. We saw that in the student loan series of cases. We saw that in the cases on affirmative action relative to the Title VI sort of related claim. We've seen that in other manifestations. And for example, Groff versus DeJoy, which was a Title VII anti-discrimination case in employment on religious accommodation grounds. These justices stick to the letter of the law as written, and as concerns the principles of the Constitution, they are originalists. They want to make sure that they are informed by the text and history and tradition of the regulation of those particular issues, but above all, with what the framers envisioned when they drafted those particular constitutional principles. It is a victory for the rule of law and for common sense. We do not want any of our justices, conservative or liberal, reading into our statutory laws or our Constitution those particular readings that are not there.
Absolutely. Now, one of the things I was reading a little bit about this is that you mentioned the liberal justices dissented, which was not particularly surprising. One of the things that I'm kind of curious about is whether this will be the end of this type of case, whether we will see continued challenges on this front, because obviously a dissent would be some form of the argument is weak on this front. Are we anticipating that there's going to be a backlash, that there's going to be sort of an attempt to get this repealed, get this sort of type of response repealed by the Supreme Court in the future, maybe with a more like-minded court with the liberals?
Yeah, I actually think that's sort of a great prediction on your part. Listen, even Neil Gorsuch, in writing for the majority in the 303 creative case, said specifically, public discrimination, these public accommodation laws and anti-discrimination acts have been expanded in notable ways. He identified the fact that we're seeing more of these clashes between the interests of Americans who identify with these protected categories and those expansion of categories to include, for example, sexual orientation and gender identity, and the principles that are concretized in our Constitution, those upon which our entire nation was founded. Listen, we know Colorado has already taken multiple bites out of the apple. It's tried with Jack Phillips not once, but twice. And now we're seeing again with Lori Smith, the exact same Anti-Discrimination Act, where she is subject to those same provisions, and thankfully had the good sense to get out ahead of it by filing a pre-enforcement challenge, which in the end rendered her victorious on principles of free speech.
Now, Sarah, as somebody who is intimately familiar with the workings of the court, I'm very curious as to what your thoughts are on what appears to be a sort of endless barrage against the legitimacy of the court. Like I mentioned earlier, President Biden said that this was not a good court. He said that this was a problematic court. Adam Schiff has sort of floated this idea that we need to, I think it's restack the court or do something along the lines that's not court packing, but it's court packing, just not in name only. Yeah. Do we see those efforts as going any further?
I think we'll see them as long as the sort of liberal party in power is dissatisfied with what we're seeing coming out of the court in the first place. We know, of course, that the Democrats have control of both the White House and obviously the very expansive regulatory state, which also took a pinning back today in the student loan forgiveness cases. But we've recognized that there are calls for sort of court packing, for term limits, for removal of certain justices, for codes of ethics. They will do everything they can to get their hands on the only non-political branch of our tripartite system. And this is something I think that we have to hold fast to. It is one of the most I would say successful and expansively protective elements of our constitutional republic. We have a system of checks and balances that has up to this point worked very well, but it requires adherence to those principles of separation of powers. Otherwise, the entire system fails.
Absolutely. Now, like I said, this doesn't really seem like this is particularly popular, I guess, with the American people. There's some polling data suggests that most people view the attacks on the court as problematic as well. I mean, you and I know very well when I was over with the Daily Signal, when I would go to the houses of these justices and just watch night after night after night where they were being followed, they were being harassed, their houses were being almost barricaded in by these protesters. My question for you then is, what is the solution to what appears to be increasingly aggressive attacks on the court? If President Biden won't stop doing it, if Adam Schiff won't stop doing it, if Elizabeth Warren won't stop doing it, what is the solution here?
Well, I think we just continue to hold fast to the rule of law, and we make sure that all of our courts, both at the Supreme Court level and at the federal court level, are protected, that we have the appropriate law enforcement authorities who are actually doing their jobs, and they are enforcing these particular federal statutes. Remember, it's a federal crime to show up outside a sitting federal justice's house. It is also a crime under Virginia law, which is where exactly many of these justices live. But we're not seeing the Department of Justice very active on things of that nature. So there will be continued infringements on these arguments for the court's legitimacy, as long as the average American believes that they can politically impact these individuals, sway them, sort of impress upon them the need to produce outcomes that might be socially justifiable. That is not what the Supreme Court exists to do. They are to impartially uphold the principles of the Constitution, faithful to its edicts and its mission. They are not to be swayed either way by political influence or party. We saw it with the Dobbs leak. That simply requires the party in power, whether that's in the upper chamber, the lower chamber, or the White House, to make sure that those justices are protected and that the security of those individuals is at an all-time premium.
So important. Sarah Parshall Perry, Senior Legal Fellow over at the Heritage Foundation. Thank you for your time. There's more to come on O'Connor Tonight. Keep it here.